Hey guys, good afternoon, class. And again, apologies for not being available to you guys this week and having to do our class lectures through a Zoom recording. As you guys know, I'm in my last week of our second to last week of the academy class, so I'm not able to physically be on. So the last two lectures will be recorded and uploaded to Canvas. Just make sure that all coursework is completed by Christmas Eve, which is or in the 2 weeks. Also make sure that, I'm sorry, not Christmas Eve, but by, I guess, the 22nd is the last day of class. Also, if you guys have any issues or anything like that, feel free to email me, and we will start with chapter 15, which is criminal law. So you have two definitions and categories of crime. What they are is felonies, and you have misdemeanors. Felonies are the more serious of offenses, and they're punishable by imprisonment exceeding 1 year. An example of a felony could be a homicide or murder, aggravated battery, aggravated sodomy, child molestation, things like that. Then you have your next offense called a misdemeanor, which is a crime that's punishable by fines or detentions of up to 1 year or less in jail. And some examples of this could be shoplifting, could be a simple battery, things like that. Mostly all of your felony cases will be heard in what's called superior court, and most of your misdemeanor cases will be held in what's called state court or your municipal courts. Also, too, we talk about the definition of a crime. This definition I don't like, but it's what the book gives you. It's a positive or negative act or an omission that violates penal law of the state, of the federal government, and an act done in violation of those duties for which an individual offender should make satisfaction to the public. Acts that may be injurious to an individual and society. Pretty much a crime is pretty much what it is in layman terms. It's a violation of just a civil or a government statute or government code. It's pretty much, to make it in civil terms. Again, crimes vary from state to state. Crimes vary from nation to nation, country to country, but in the United States, we do have some uniform crimes that are kind of similar in each state, but the only thing that differs is the penal or the penalties for those crimes in such states. So we talked about, you got these two different types of penal codes. You got the common law and you got the model penal code. The common law looks at things about general intent and specific intent. So general intent, just to give you an example, is driving above the speed limit. And specific intent is deliberately running down a pedestrian. So you're probably asking, what's the difference? General intent is pretty much saying that that I'm just driving my car, and I'm just driving down the interstate. The speed limit is 75, but I'm doing 85 and just not doing it. It doesn't have any intention, or you're not doing it purposefully, but it's just something that just happens in the course of your everyday life. Whereas specific intent, like the example says, deliberately running down a pedestrian, you set out to do that specific type of intent, which led you to commit some kind of criminal act. When we look at our model penal code, we look at negligence, reckless, knowledge, and purpose. Driving the speed above the speed limit is negligent because you sit there and know that those limits are put in place, but you're negligent because you don't follow them. It's a lack of responsibility, our culpability with those types of offenses. Reckless, pretty much reckless is that the act itself is reckless. Driving while intoxicated, it puts others at fear, or others' lives at danger. So that's what makes it reckless. And you have knowledge. Knowledge is pretty much knowing that something's wrong, but you still do it anyway, even with the fact that it's a wrong thing. And the purpose, your purpose for doing the specific act is pretty much what it is. What it pretty much says is the purpose of doing that specific criminal act. Like our example before, deliberately running somebody down, your purpose to run that person down was to injure them. So it had a purpose to it. You also have two elements of criminal conduct. You have actus reus and mens reus. Actus reus is going to be your physical conduct. What actually took place, what act was the accused capable of, and what was the result of the crime. The mens reus is the mental conduct, or we also call it guilty mind, and that's going to incorporate our specific intent and general intent when we break it down under mens reus. Then you have what's called, the next thing is parties to a crime. Principal parties in the first degree are parties who actually take part in a criminal act. Again, it goes back to actus reus. but they do have a adequate account of mens res. So for example, if me and my friends decided to rob a bank and that we went with that bank robbery and the friends of mine committed the robbery, but I sit there and stayed back, even though I planned it, they'd be a principal in the first degree because they were the ones that actually took place in the criminal act. Principals in the second degree are those persons who assist in crimes or whose conduct enables the crime. So if I helped plan the crime but didn't actually do it, I would be considered a principal in the second degree when it comes to those types of criminal acts. Then you have what's called accessory before the act and accessory after. Pretty much, again, these are very common terms and common sense terms. You just read them and kind of, if you know what the words are, that's what they are. Accessory before the fact is pretty much somebody who helps them out. Again, bank robbery. If we plan a bank robbery, I work for the bank and help the robbers get in the bank because it's an inside job. I'm an accessory before the fact. Now, if I help them and assist them in getting away, even though I wasn't involved in the direct bank robbery, I'm an accessory after the fact. Then you got in short offenses, which are such things as conspiracy to commit a criminal act, crime of attempt, and crime of solicitation. Conspiracy is coercing with two or more people to commit an offense or criminal act. So that means if two or more people got together and developed a plan to do a robbery or a burglary, that's going to be conspiracy. Two or more is what the key element is at. Criminal attempt. A criminal attempt, even though it says mens res occurs but actus reus, that's going to confuse you guys. Crime of attempt is pretty much making an over-exaggerated effort to commit that crime is what it is. They may not completed it, but they made an over-exaggerated or physical enough effort to commit that crime. Crime of solicitation is what it is. Pretty much we hear about solicitation and prostitution. If you think amongst that line, that's what it is and you'll get it. So solicitation is pretty much what it says in our definition: enticing, inviting, requesting, urging, or ordering another to commit a crime. Some miscellaneous offenses are character offenses, which is illegal possession of weapon, possession of a large quantity of drugs, and burglary. Again, all drug-related, weapons-related, and property-related offenses are in short character offenses and miscellaneous. So again, here's some examples of your felony crimes: assault, battery, theft, robbery, and homicide. The most serious of these and the most frequent of these is going to be theft, robbery, and larceny, where the most second is going to be battery, with the third and assaults, and the third being homicides. So electronic media crimes examples is cyberbullying, public safety issues, identity and asset theft, invasion of privacy, cyber threats, hacking, viruses, pornography, and fraud. Under the common law and model penal code, they pretty much say the greater degree of specific intent resulted in more severe range of punishment. So pretty much what they're saying under common law model penal code is the more severe the offense, the more strict or more severe the punishment. For example, a lot of criminal offenses can have things up to life imprisonment or the death penalty. So that's pretty much for some of those types of offenses. For example, a homicide or murder in Georgia could be recommended for the death penalty or imprisonment for a long period of time. Some other types of punishment is monetary fines, which are pretty much fines for criminal attempts, where you hear that the person has to pay a fine of $10,000. And also another type of modern punishment is community service, where that person has to go out and pretty much work for free to work off some of their punishment. Some white collar crimes are crimes in the workplace, and we see this quite a bit with more wealthy and big industries. You have tax law violations, burglary, theft of trade secrets, and damage of competitors' property. Persons representing corporations are as mine, and their respondent superiors allow corporations to be held responsible. So pretty much white collar crime is what it is. If you think about white collar, think about suits. All businessmen have those nice suits with those white shirts, and that's where white collar comes from. So when you look at white collar crimes, you think about, let's say, Kelly Loeffler or David Perdue being accused of insider trading when we learned about COVID, or if you think back to Martha Stewart when she dumped a lot of her stock when she found out that her company's stock was going to tank and she sold it. That's considered insider trading or theft of trade secrets. That's what makes it a white collar crime. Some common defenses to criminal conduct: justifiable or excusable conduct. You have involuntary conduct, duress, mistake, and entrapment. The insanity defense or McNaughton rule is called a mental impairment. So pretty much what we do, and I've worked on cases such as these, is they're pretty much saying that the insanity defense is pretty much saying the defendant during the time of the criminal act and was not in right mind, sound mind or body, and that did not comprehend the acts that they did or the criminal act that they done. And so because if this person is found to be incompetent, then what happens is it prevents the judge or them from sitting there and taking an incompetent person to trial, and that they can't be sentenced for their crime. A lot of times what they'll do is take pleas and end up in mental health facilities and facilities such as that. Also, too, you've got the irresistible impulse theory and insanity statute. These are really rare when it comes to court, and you don't see them as much, but they are brought up at time. Most likely you're going to see the McNaughton rule. And in order to enact the McNaughton rule, what happens is if you're going to prove somebody to be incompetent, you have to have what's called a competency hearing, which is requested by the attorney. At that time, that person or that offender, defendant, will be reviewed by a psychologist or a psychiatrist. And at that time, that psychiatrist can write up a narrative and come testify in court to that person's competency level. If they're found to be competent, the court case will move on. If they're found incompetent, then what happens is a competency plan is developed to bring that person back to competency so they can stand trial. Or what the courts will do is they'll enact some type of hearing so that per individual, or may take a plea deal so that individual may be placed in a mental health prison until further they're released. So that is the end of the criminal law lecture. If you guys have any questions, just let me know and I will get back to you. Give me an email and I will see you guys next week.